Okay, good afternoon. How are we doing? Plenty of room back there in the cheap seats, I see. How many people here from the East Coast? It's 6:45 at my house. It's time for dinner. But that's not why we're here. We're here to talk about the next generation of courts and strategic planning and what it takes. I'm proud to be from the state of Georgia and present to you Mr. T.J. BeMent, who works at the 10th Judicial District in Georgia. And he's going to explain all that to you in a few minutes. But I do want to remind everybody that Georgia is one of the original 13 colonies. I know because that's the year I moved there. So with that, I'm going to turn it over to TJ.
Good afternoon, or I guess as Steve said, in Georgia, good evening. Thank you for all having me here today, and obviously this is one of our recording sessions. This is also one of the live streaming sessions, so I have to give a shout out to anybody in the world that might happen to be watching us. I think a few of my colleagues are, so this is just for them. Stay happy, my friends. My name is T.J. BeMent, as Steve said. I work down in Georgia. I'm a regional administrator. I'm going to give you a little bit of background and context of our system in Georgia because it'll make some of the discussion make a little bit more sense. How many of you all are from what they call a unified or a centralized state? Oh, wow, okay, only a few of you. Last session it was much more, quite the opposite. How many of you all consider yourselves either a decentralized or a non-unified judicial system? Okay, what does that mean to you all? See, in Georgia, we don't even use those terms. Okay, we are local autonomy, decentralized, local control. We are very much a county and city funded judicial system, and with that comes county and city run or city influenced judicial system, unlike some other states that might be more unified, where everything's a little bit more top down and more unified procedures. So that's going to give you a little bit of the context here as we talked about and embarked on a process that took many years, about 3 years almost, 2.5, 3 years, in Georgia to talk about what the courts in our state would look like 20 years from now. So in the context of a very local-based, very autonomous-based judicial system, it's hard to have some of those conversations when you're trying to look at things across the board and things that go across court structures. It's not a municipal court issue or a probate or a general jurisdiction or appellate or a Supreme Court issue. It's across the board. So we had to get all those types of individuals together to have this conversation. So welcome to the Peach State, for those of you who are from the South. I'm actually, my office is based out of Athens, Georgia. Anybody follow football? SEC football? Then you've been between the hedges at some point or another? Go Tigers. Well, I have to say, much as I am living in Athens, I did not go to the University of Georgia, so don't hold that against me for those of you who are LSU fans or someplace else. What's that? Gamecocks. Oh, wow, that was a good game this year, too. So a little bit about Georgia. Pretty populous state. We have 159 counties. We have 159 elected clerks of court. Those 159 counties then roll up into 49 judicial circuits, and those 49 judicial circuits then roll up into 10 judicial districts. Second only to Texas in the number of counties. So as I mentioned earlier about very much local control and local autonomy, all these individual counties here have a lot of individual control. We have some counties that are as non-populous, I guess would be the word, as about 1,800 people. And then we have those in the metro Atlanta area that may have several 100,000. I happen to cover a northeast Georgia here up in the 10th Judicial District, and I've got 21 counties in there, my smallest being about 2,200 people, my largest being a little over 200,000 people. So, and I cover 6 circuits. So, in Georgia, much like everyone else, Supreme Court, Court of Appeals, I work for our superior courts, which are our general jurisdiction court in Georgia. We handle everything, as you can just guess. Down here, then we have 5 different trial courts, down to the municipal level, at the city level, and then all of our different county courts, our magistrate, which are our initial hearings and small claims, probate, your wills and estates and guardianships, juvenile court, obviously, and then state court, which is an optional local option, which is basically a misdemeanor court. So we've got those spread around the state. You can see the numbers of the ones that are in every county. We actually have about over 400 municipal courts now in Georgia, and I think we've got closer to about 75 state courts now. So very, very different. The key to knowing about is each one of these on here, with the exception of the Supreme Court and Court of Appeals, your Superior Court and all your trial courts, each one of them have their own governing council in the state of Georgia. So when it comes to their rules of procedure, how they operate, their legislative priorities, their strategic priorities, whatever it may be, all of them have their own governing council. They all then get together, and representatives of those governing councils then go up here at this level and become part of a state judicial council that is primarily a little heavy-handed, with our superior court being our general jurisdiction, with representatives from all the other classes of court, including the Court of Appeals and the Supreme Court. So that function of that judicial council is to approve overall judgeships for the state at the superior court level, as well as some policy matters and overall legislative priorities. So where did that leave Georgia? A couple years ago, our then president of the state bar, Ken Shigley, and our then Chief Justice, Justice Carol Hunstein, we're talking about some strategic priorities for the courts. You know, the state bar president and the Chief Justice get together, you know, have, share coffee and chat with one another. Well, what major technology thing do you think our state bar wanted? What, really? I'm shocked. State bar and your attorneys throughout the state want e-filing. Is that pretty common everywhere else? What do they really want when they say e-filing though? E-access. They want to be able to file it anywhere, and they want to be able to see everything from everywhere. So that e-filing discussion led into a e-access, or really a e-everything discussion. And as you can imagine, in a state that's very locally autonomous, coming up with a statewide solution for something like e-filing, not going to happen overnight, and not going to happen with a whole lot of political discussion. So the two of them got together and said, rather than forcing some discussion on e-filing that will take a while, why don't we take a step back and start collaborating, get some folks together and talk about where the courts need to be from an all-inclusive standpoint, with representatives from all the classes of courts, plus some lawyers, plus some lay people, plus some legislators, plus some other folks, and get them together and talk about where the courts should be heading. So from that came the creation of the Next Generation Courts Commission a few years ago in the state of Georgia, headed by the state bar and appointed by the state bar and by the Chief Justice. They appointed one of our Superior Court judges to chair this commission to talk about technology initially. Their mandate was actually broader, to talk about where courts were headed over the next 20 years. So that led it into the charge of a commission to talk about where we were heading and come up with a series of recommendations, tangible recommendations, about issues facing the courts in Georgia over the next 20 years. Now, what we embarked on over the nearly a 2-year process was to go through re-engineering, future planning, environmental scanning, and all of those kinds of big picture thoughts to talk about where we were going to be in the next 20 years. So what I'm going to lead you through over the next half hour or so is how we went through that process, hopefully give you basically a toolkit of instructions should you want to do this at your city, county, or state level, to have a discussion about the futures of your particular court. And then I'll share with you some of the results that actually came out of our recommendations, and you'll see how similar them probably are to things that you've already talked about. So we had a commission chair, a Superior Court judge, but what happens when one of your judges is assigned to do some heavy lifting? You all are mostly court administrators, right? Who do you call on? You're court administrator, right? Guess whose court administrator I was? The chair of the commission. So where your judge goes, we dutifully follow. So one of my judges, who's a very energetic and charismatic personality who many times would have his own comedy routine when we come to our judges meeting, was assigned to bring a disparate group of individuals together. So you can already see some of the magic of the politics working behind the scenes of getting someone who was well respected, a former legislator himself, very well respected in his local community, and very well regarded by judges throughout the court system in the state, and somebody who is just very entertaining. So you put all those together, and then you get to talk about future issues. So with that kind of excitement from that judge, we got folks together, signed a variety of different program areas that came out after the first initial conversations. You don't need to worry about the topics at the moment. But you can see we got folks from a variety of different backgrounds. One piece of note, though, this commission, and it may differ from state to state if you do something like this, was very judge-driven. It was judge-driven, but court management supported. And I choose those words carefully to say that it was very much about the judges and a conversation between judges and attorneys for the most part, but behind the scenes was a very strong role by me and some others from the court management perspective to bring topics and to bring management type of topics to them in their thinking as they went and looked at what the courts would look like in the future. A lot of people on this commission started out with about 25. By the end, it was nearly 60. No surprise, once people got started, other people wanted to get on board. You'll see a lot of the HONs at the front of people's names, see a lot of judges on that. What that largely was comprised of was nearly 40-some% judges. About a fifth of them were clerks. Again, with 159 elected clerks of court in our state, we had a good amount of clerks on our commission. Then we had a handful of attorneys and some court managers and some other folks, and we largely lumped a lot of the court managers to people that were in management type functions at the statewide level. Variety with courts were represented. The bulk of them, that 38% you see on the right there, are largely our superior court judges. Being a judge-driven commission and policy group that came together, judges tend to surround themselves with like-minded souls and folks. So our judges got lots of other judges together, which was a good thing because at the end of the day, what we were trying to get there was not what court management wanted to talk about, it was what judges wanted and needed to talk about for them about what the future of our courts would be in our state. So, who are your leaders? Who are the people that you would want to have, as they use the phrase these days, on the bus with you? Who would you put in the room? Any takers? Funding authority, such as what? Sorry, what was that? Legislators. Yep, we had a couple legislators, and the legislators that we did have in there were some of the key representatives from our Judiciary Committee at the House and the Senate. Who else would you put in the room? Community members. Yes. Did we have any of those on our committee? No. Should we? Yes, we should have in hindsight. It would have been great to have our legal, one of the pro bono legal services providers or one of those types of group or legal aid societies. Would be great to have that, but the politics and the pace of it didn't support that. Anybody else have who else would you put in the room? Employees. What kind of employees? Yes. Did we have those in the room? No. They were not on the bus. Arguably they were under the bus, sometimes caught up under the wheel well, but they were not. There were actually only 3 court managers in the room. Myself, our AOC director, our Administrative Office of the Courts director, and the director of one of our judges' councils. All the rest were judges, lawyers, a couple lay people, other attorneys, etc. So yes, having employees in the room would have been wonderful, but given the context, and this is where states may differ about the politics, given the context of that, we had the right people in the room because we saw them as people who had some authority and had a following and able to influence others. So depending on what your context and what your goal is, you may want to actually have some employees in the room. Anybody else you'd have in the room? Human services, such as treatment providers and stuff, okay. That would be great to have in the room. Did we have them in the room? No. We do have a lot of accountability courts, which are like drug courts and stuff like that, and we had several of those types of judges on there.
Do you have help people from your IT world, like information officer, CIO, something like that, for the state or that sort of thing?
Yes, we had one. We had the chief IT officer of our AOC was there. But again, in a perfect world, depending on the context of what you're dealing with, having those IT folks in there. But at this level, when we're talking about what the future may look like and some of the trends and analysis 20 years out, those types of folks, while helpful to have in the room and certainly useful, might not necessarily have been part of this, because we wanted to engage in a conversation mostly amongst judges, legislators, and attorneys from the state bar about what they thought the future of the courts would look like. So we actually didn't get into those kinds of weeds that sometimes having the IT folks in there would get in. As I go through some of the scenarios and stuff, you'll see why. So we tried to look for partners, participants, supporters, and influencers that would be part of this discussion. I liken when you all take this back home, and if you decide to do it yourself, you get to go dance. Everybody knows who Sai is, right? No? Okay. I won't dance for you. I won't play the music. I won't play the video, but you can ride that horse all you want. So do your Sai brainstorm back home, thinking about who those different folks are, because you need a little bit of both. If you just have supporters in there, then you're not going to be able to accomplish something if you need to take this into some form of action. If you have influencers, then you may not be missing the people on the front end, such as employees who are the participants, the direct folks that know the day-to-day work. So you have to have a little bit of mix of everybody. So generally with some of our choosing, since a lot of it was political, we may not have always had some of these representatives, but we tried to make sure quietly through some of our additional folks that we added after the first round, that's why I got up to nearly 60, that we had a good smattering of folks from these different categories. So how do you do it? We did a lot of trend analysis. We went through a lengthy exercise with our judges over the course of almost 2 years in conjunction with a lot of our state court folks and a lot of our state bar, pairing them up with the state bar meetings and other opportunities, a lot of phone calls, teleconferences, but mostly a lot of in-person meetings. Surprisingly, when we're talking about the future, it took people getting in a room together to talk about those things. Not getting online, not getting on a webinar, not participating on a phone call, getting people in a room, looking at each other in the eye, around a circle table, having a conversation. So we did some analysis. We looked at a lot of stuff at the state level and the national level. Obviously, our big thing was talking to the commission members themselves, the people on the committee. We looked at a statewide survey. We did some old reports that our state had produced. We did the grunt effort of going through and pulling all the strategic plans at all these different judicial councils in our state and pull out all the little good bits and then turn that back and put that before them. They didn't have to do any original research themselves, not that they couldn't have, but we inundated them with quite a lot of information. Went through various state trends, civil legal needs of the low-income individuals in the state. We polled our state bar and asked them what some of their priorities were when it came to future issues. Surprisingly, what was up at the top? E-filing. Again, not a surprise. But when it got down to it, they started talking about things that we didn't think they really cared about. We didn't really know that the attorneys really cared about interpreters or court security. What do state bar members really care about court security? They see things in the news, right? But that was actually one of their top priorities. I guess perhaps when there's a courthouse shooting, they feel as vulnerable as the rest of us. I don't know if any of you all are familiar, several years ago in Fulton County, which is Atlanta, that had the inmate that escaped from custody while at the courthouse and then went on a rampage, shot a judge, shot a court reporter, shot a U.S. Marshal, and went on a rampage throughout the city, and then ultimately that case then nearly bankrupted the public defender system in the state of Georgia. one case can have such a profound effect. So those things still linger in our psyche in our state about having things like court security. So it was interesting to hear that the State Bar weighed in on that as well. We looked at a report from the American Bar Association. They talked about specialized court functions and services, adequate state-based funding, and staff resource issues. And a quick note, this presentation is online for those that are interested in it at the NACM conference site. Anything you see down here in yellow that's underlined is a hyperlink, so you can go to these source documents if you want. Certainly the National Center for State Courts, we presented to them about the last 3 years of the future trend reports. Has anybody ever picked up one of those and read them? A few of you. If you don't, read it. Comes out every year, right around the spring, if I'm not mistaken. I think it's all digital now, though they do still print it, but go and read it. It tells you and it will keep you more cutting edge. We sliced and diced the last couple of years and presented it to them, to the commission members, and engaged them in a conversation about the topics that were raised in there, and it was very helpful to them. These were sort of a summary of a couple of the ones that came up. Obviously, technology issue, special programs, specialized court services. You're already starting to see some themes pop up. At the time, the National Center for State Court was doing its Harvard papers. Has anybody read any of those, like Herding Lions, governance principles and whatnot? Again, if you haven't, I encourage you to read them. They're all online, or talk to the National Center and get them mailed to you. Great reading, very easy reads. Give them to your judges, give them to some of your leadership staff. Not all of them were completed at the time when we were doing our commission work, but we did present those to them and made them part of the reading materials for the commission members. Anybody know what this is? Y'all have hopefully seen the national agenda by now of NACM. We quietly put that in under the surface. They didn't quite know what the national agenda was. We didn't tell them that it was the national agenda of NACM. We just said it's some of the national type of priorities when it comes to court management. So again, kind of quietly, court manager driven, or judge driven, but court manager supported. We kind of put some of these topics out there and got them to talk through some of that as part of their discussion. And again, we talked about why it's important. Has anybody sat in on Peter Kiefer's and Phil Knox and Nicole Garcia's session? Y'all, I think it was the last session right in the same room. Have you all go to that? And have you all been to one of their sessions? I think they've had one at most conferences for about the last year. If you haven't seen one of those sessions, I encourage you to go back and watch one of the videos or ask them for a copy of one of their surveys. They're doing an updated survey this summer. Really great work. Obviously, we got one of their earlier versions when we were going through our process here, but they really take a look at what some of the scenarios will look like as far as courts in the future. We presented those to the judges and to the members of this commission. Scared them. When we talked about courts being completely paperless and, the e-access everything and some of the demands and, user-based fees and all those kinds of scenarios that they threw out there as being somewhat likely, and centralized data storage. Sometimes we had the deer in the headlight looks with the commission members. The rest of the time they're like, it's not going to happen here. Again, since we had a lot of attorneys and a lot of judges in that commission, it was a very visceral reaction that they had to some of those scenarios. But it was also eye-opening in the context that it got them talking and it got them thinking and interacting about, well, wait a minute. We might be facing some of those things. When they were able to distance themselves long enough from the cases pending that they had to go back to the next day and say, we're talking 20 years from now, right? Well, then some of those things might be closer to reality. So again, kept them thinking. We tried to quietly put some of these things in their mind, re-engineering versus rethinking, and environmental scanning and whatnot. Trying to keep it at a very, very high level to keep the conversation ongoing with them. So we presented them and gave them some background material. We didn't make them read all these things. I have them up for you all. These are both links in the documents if you want to go in and read those papers. Very, very helpful. One of the things we were able to get, and I'll show the slide in a moment, is Laura Claversma. I believe she was just in the last session. She works for the National Center. She does some consulting with them. Because when we were doing this, because we used the phrase re-engineering, and that was part of what we were having in this conversation, we got free technical assistance. At the time, they had a BJA grant or an SGI grant, can't remember which one, they may still have. So I encourage you to reach out to the National Center, ask them for help. They may be able to provide. Laura actually came and sat in on a couple of phone calls with us and came in person to one of our commission members and was there to help them with some discussion and provide us this initial survey instrument that we use to then leapfrog off of. But certainly reach out to the National Center. They may be able to provide some technical assistance. So we quietly introduced to them some of the re-engineering concepts as applied to the court system, and threw out some of these topics. Let's talk about automation today, or let's talk about things going online and what does that really mean, or does redistricting, redefining jurisdiction and venue have an issue? So we talked about some of those things with our commission members as a springboard to discussion. So we talked to them about how, what is the life cycle of an organization, that we go from growth to maturity and decline, and then we start to turn around and start back over. We told them that they were right here, or maybe in maturity right now, but over the next 20 years, they're going to have to reinvent themselves if they're going to stay current. So we got them to really take off their judge robes, take off their ties, literally, because they were out of the office, and have a conversation and talk about what things would look like. So we went through an environmental scanning process. Again, we didn't show them all this stuff, because if you think you have deer in the headlights eyes right now, think about a room with 60 people in it, most of which are judges and attorneys who were just glad that they're in the room. We didn't go through this, but we quietly talked to them in the same context. We actually made them go through a SWOT analysis in their little committees and talk about it. And we put it in different terms that are more easily digestible to keep that conversation going. But again, it came to having those stakeholders there and giving them that overall mission and keeping them on target. Here's just a great definition for environmental scanning if you all want it, if you decide to take this back to your local programs. Again, some great information material there on what environmental scanning is, about gathering information from a variety of sources and bringing it to your folks. But what we ultimately got them to do was this: in a future trend concept, talking about what are the trends after going through and talking about National Center and NACM and the American Bar and the State Bar and their own discussions, et cetera, what trends are we likely to face? Were those trends important to our state? And are we actually going to be able to deal with them? As we started to go through the conversation and have these breakdowns, they were able to start putting things in greater context. So we then talked about, are those plausible? Are they relevant? And are they divergent or challenging? And then continued on. So ask for help. If you can't put things in the context of re-engineering, there's Laura's contact information. Reach out to the National Center. So we then did a national survey. This was based initially on a survey that the National Center helped the state of New Mexico do. We sent a survey out. You can see that the majority of our respondents were attorneys, followed by judges and court employees of some sort. And we sent this out, the link out to the State Bar, to the judges groups, to our Council of Court Administrators and various other groups, and then got feedback back. If any of you have ever done a survey, don't do a survey like this. And for my folks at the National Center, if anybody's gone through ICM, I know they will shudder. This is only some of the questions. There are more, and there are more, and there are more, and there are more. That's a lot of questions. And this was the slimmed down version from what it was that we got from New Mexico. Don't do this. That said, we had gone through a lot of effort to put them into broader categories, such as education outreach, had a brief little snippet to tell them about what they were doing. We did follow the same methodology of, was this definitely worth considering, neutral, not worth considering, stay the heck away from it. So we had that same context follow throughout the questions, and actually if you did the survey, it only took about 15, 20 minutes tops to go through it. So you'll see here, the orange bars are really, really good. The blue bars are also good. So you'll see some of the ones kind of come out the top. So you'll see here, strangely enough, the topmost answer that came out on educational issues was ethics. And statewide survey, top thing that came out is ethics. And we'll go in that in a moment, what that resulted in. We had some other interesting ones, uniformity, not surprised, uniformity across all courts in terms of access and forms and whatnot. Technology, oh, shocker, e-filing, e-access, electronic means to distribute and publish more court calendars and court records and whatnot. No surprise, some of those results. Here, the biggest one, though, surprise down at the bottom, it got cut off, require attorneys to put their email addresses on filings. And guess what? That's actually a statute. They're not even following the law. The attorneys themselves are saying, we need to put our email addresses on. Yeah, that's because the law says you should. So, there were some little laugh moments amongst our commission members of, oh, wow, gosh, maybe we should actually start by following the law, and then we'll get to where the court should be in the next 20 years. Program improvements, as you start to get into some of the fuzzier areas, things that get a little stranger, more accountability courts in Georgia, that's what we call drug courts, DUI courts, mental health courts, and whatnot. Funding, lots of questions on funding. This actually came down to a small number of recommendations, but largely the ones that came in here, the biggest response right here in the middle, provide funding for technologies in the courts equivalent to the private sector. And since a lot of our respondents were attorneys, what do law firms have? If they want to invest in something, they invest in something, right? If they can show return on investment, say it's going to help us handle our caseload a little bit better and whatnot, they'll invest in it. So there was a realization of the courts need to invest in technology and court functions and stuff just like the private sector does, perhaps even more so. So what happened? We came up with a list of recommendations and whatnot, and we'll sort of walk you through those here for just a moment. Primarily state-funded education. Again, because we're very decentralized and a lot of county and city-run courts and judges, the funding for judicial education is on the backs of the cities and the counties. So there was a resounding recommendation that percolated up through this process of, not necessarily now, but the next 20 years, if we want to be successful, state-based funding so that we can have an adequate, significant amount of education. Educational, increased education, the normal kind of things, online, distance learning, remote learning, etc. Interesting one here, advanced training for judges. This didn't come out from our judges, this percolated up from attorneys. Taxation, assessments, your tax appeals, your property assessments, torts issues, medical malpractice, business law, all those kinds of things. Did your judges go to law school to be experts on those? No. So there was a realization that judges, that once they're on the bench and they start getting these complex cases, they may not have that expertise. There's a real big push to have some specialized dockets out there for complex business cases, complex tort cases. These kinds of things in our world in court management come in like, wow, that really sounds like differentiated case management and some of those kind of concepts. Kind of percolating from different perspectives, those are things that attorneys were talking about. Judicial bench books obviously being more helpful to our judges from an education standpoint. New judge orientation, all the judges kind of came up with that. Advanced training for judges. Here was the ethics. That ethics question, and there were several others that sort of hinted at it in the survey and then in the discussion with the commission members, started out as more ethics training, but by the time it made it to its recommendation here, it became gender issues, sexual orientation, and limited English proficiency as specific topics that need to become under the ethics topic for judges and court staff to be trained on. So it's certainly a long-term issue for our state to have more training in those areas, and we're starting to see a little bit of it. Our state judicial education center is actually jumping all over these recommendations and putting them on a timeline to start looking at them. And lastly here, support training for clerks, court administrators, and court personnel. This didn't come from the judges. This came from the attorneys. Why are they saying that? Because it's true, what? Because that's how they have to do it. And we, after the survey, we gave the judges about a 20-page paper of some of the comments that people gave us after the survey. We extracted all of them and anonymized them. Some of them were several pages long of attorneys that kind of went in. And the resounding thing that came out that generated this was, you put your lowest paid staff member on the front counter, answering the phone and filing the documents that have no context of where they are, what they're doing, or why it's important. They need training, they need your support from a management perspective, and you need to invest in them. Because those are the people that have to get it right on the front end to make sure that that case goes down the proper pathway, that it gets entered correctly in the system, that it goes, to be listed as a tort versus just a normal civil case. That kind of investment in technology and training for court staff became really important. And it was very eye-opening, I think, for our judges, because they don't think about this. They just get the case at the end of the day. They don't realize whether or not the case got entered wrong or the person filing the case got bad customer service. So that really generates some topics. And certainly in our state now, we're actually about to engage in an access and fairness survey over the next year. And hopefully we'll see if some of this kind of bears fruit to eventually lead to some additional training for court staff. Transparency, putting things out on the web and putting access to information. Public understanding and support of the judicial system. This came up as a really interesting one from a civics perspective. You heard me talk on that last one about court staff and line staff on the front end not really having the context of where they are and what they're doing is why what they're doing is important. Civics education came out as a result of this. And this, we think, maybe quietly from the commission members might have been some of the lay people on the commission, or perhaps some of those state legislators in the judiciary committees saying, we don't know what the heck y'all do in the court system, we try to cut you and you say no, and you say you have 95% of your money as people, and we don't understand what you do and why that's important ourselves. So this came out saying that there is a mandate, there should be a mandate that the judges in the judicial system do a better job explaining what it does and why what it does is important. So we hope in time that this will go into something that will be part of a discussion through our different judge councils and eventually come into a training program that can be shared out. And certainly working with our state judicial education. Again, more public service oriented procedure, statewide civics there as well, appropriate efforts for pro se. The pro se issue came up here in the outreach. It came up in the program improvement context as well. Plain language, standardized state forms. How many of you all have an issue where one court in your state uses this form, another court in another part of the state uses the same form to get to the same place? And if they happen to find one of those forms on the internet from County X and they want to use it in County Y, what does County Y say? No, thank you. Even though it's the same information, even if they scratched off Y and put X or vice versa, people aren't comfortable with that. So that came up from a variety of responses from our commission members in our survey about having standardized forms. Utilizing our law libraries to provide information, having better alternative dispute resolution and low-cost mediation efforts and stuff that came up. Here's a really interesting one that came from our attorneys. Our attorneys in their discussion in the commission said, we don't do good enough job turning out good attorneys out of our law schools, because they leave law school having no courtroom experience. Is that a surprise? They have the moot court and the practicums and stuff like that, but they have very little hands-on experience. There was a real push from them to say, if you've got a law school nearby in your jurisdiction or in a jurisdiction next to you all, you should go to that law school. They should be showing up and doing mediation and doing efforts in your court and being part of the court system so that they can get some firsthand experience and some real life experience. And that if we aren't doing it, it's a shame. So that was really interesting for our judges. So I think that's something that will become a partnership at some point over the next several years with our law schools to do better interaction and better utilize the law students. We're having a juvenile justice reform in our state. I don't know if anybody else is going through one of those on the pendulum swings right now, about having more attorney representation in juvenile cases for guardians and special advocates and whatnot. So no surprising that came up. Not a surprise as well, accountability courts, DUI courts, mental health courts. Everybody's got those these days. Anybody not have them? Okay, pretty much no, one person doesn't have them. You're probably obviously the minority in the room then. Most people do. Really big, catching on in Georgia. 3 years ago, we had about $2.5 million funded by the state for accountability courts. We have over 14 million now. So our governor and our legislator have really gotten behind that as part of criminal justice reform and are really trying to push the creation of these types of programs. So we'll probably see naturally that the commission recommended continuing the push for those. Statewide e-filing, now that we're in technology, no surprise that it's the #1 response, followed by electronic access. Okay, so we met our goal of making folks happy at the state bar. But as it gets to below that, we got into personally identifiable information. Surprisingly though, the law says that's already supposed to be protected. And who's supposed to redact that information in most states? The parties, right? It's not the court's responsibility to redact it unless it's an identifiable information that we created in the court system. Our state, like most out there, that burden is on the parties to redact that information. Yet it's not happening. And even the attorneys are saying, well, this has to happen, you gotta do this. Well, we're also saying, well, it's the parties, and pro se parties and attorneys, and the prosecutors that are dropping off the witness reports and the incident reports and filing all that stuff that has all this personally identifiable information. Yet at the end of the day, the information has to be redacted. So there's a huge technology issue there potentially, certainly a potential for fraud. And a conversation that we got into in the commission is, if you're here with electronic access to everything and you haven't done a good job about this, what's happened? The world now has all of this. And once it's out there on the internet, it's out there. When you have a divorce proceeding that gets filed and has the Social Security number of the children and their dates of birth and that of the mother and the father and their home address and their assets and this and that, basically you've given somebody everything they need to commit fraud and then some. So a great discussion kind of ensued from there saying, wow, we really need to do something about this. I'm glad we only have to worry about that in 20 years. So they kind of realized that we need to be worrying about that probably a little bit more in the near future than later. A web-based central registry of attorney conflicts. Guess who this came from? Who said what? Attorneys. And who do they want to have do that? The court. But surprisingly, when we actually talked to them, they said, we'll do it. State Bar said we're interested in helping out in that. Again, in the context of 20 years from now, having a centralized registry of attorney conflicts probably makes a whole lot of sense. Getting that done now in a state where we have 159 elected clerks of court that have 159 different case management systems at the Superior Court system alone, then 400 municipal courts that have 400 municipal court systems, and probate courts 159 juvenile courts, and each of these have their own case management systems, and having all those things taught together, that's not something that's going to happen tomorrow. But in the context of 20 years from now, perhaps we need to start talking about judicial information sharing on a broader context if we're going to make some of these things a reality. Here, business process improvements, maintaining trial evidence, no surprise there. And I say that no surprise because in Georgia, and I'm not sure if anybody else is like this, our court reporters are all independent contractors and they have all of the evidence. They have the drugs, the knives, the guns, the photos, the bloody rags, the whatever else, and half the time it's in the trunk of their car, in their storage unit, in a closet at their home, etc. So there's talk about some of these things long-term saying perhaps these things need to be fully in the custody of the court, and eventually they do make it to the court once the case is done. But these things need to be with the court system and properly marked and evidence. So you'll see some of the politics kind of come out with commission stuff. So don't be afraid to touch that third rail for those of you who are in one of those Chicago, DC, New York type of cities, or the electric fence if you're in Midwest or whatever. Don't be afraid to touch those wires. Support the ability of the clerks of court to charge for things as necessary. Work on court reporting issues. I think I only have one person here in Georgia. She knows that the court reporting issue is starting to trickle up. We did this report about a year and a half or so ago, and now the court reporter thing, no surprise, is popping up and it's a topic of conversation. Appropriate technologies for court reporting, remote interpretation. A lot of folks, and I know the folks in Arizona have done a really good job with that. Others will probably do that too. Funding. Support an increase in state-based funding to provide assistance. We realized, and the commission realized, that if we are going to make sweeping changes to respond to a lot of the trends in 20 years, we need better statewide funding. We can't keep saying, do this, and oh, by the way, here's no money. Counties and cities go pick up the bill. There was a lot of discussion on that. Legislative changes that allow for established self-funded blah, blah, blah. What that means is user-based fees, even though everyone on the survey said, don't charge me more user-based fees, the commission came back and said, user-based fees, if you're going to do them, let them go for the intended purpose. How many of you all have tack-ons on civil cases or on criminal fines, et cetera, for this fund and that fund and the spinal injury fund and the DUI fund and the jail construction fund, the peace officers retirement fund? I mean, you could probably list 10 or 12 of them, right? Absolutely. And where does that money go? I don't know. It's supposed to go to these funds that are supposed to support these worthwhile efforts, but over time, the statutes have evolved that basically allows the money to go to the fund, and it just turns right about and it goes into the general fund, and then the general fund never allocates that same amount of money back to those originally intended purposes. We are notoriously bad for that in our state. So the commission kind of said, if we're going to have user-based fees, let the courts use them for that which they were intended. If they're going to charge for copies, let it stay with the clerk. If you're going to charge for a building fund or a technology fund, let that money stay with the court that it started from so they can reinvest that money into providing the service for which it was intended. So it was kind of an acknowledgement to that process. So of this, only 2 funding recommendations out of this whole thing: more state-based funding and the user-based fees. What was missing? We didn't talk about some of the expanding functions of the courts. We did not talk about some of the business and economic pressures, foreclosures, increase in torts or medical malpractice cases, things like that. And this is where you all, if you decide to do this at your county level or state level, may want to look at some of these other areas and put them out there as topic of conversation. Some of these came up, but for one reason or another, through the discussion process, got dropped. We didn't talk about security and facility issues, even though the security was one of the highest rated issues from our survey. At the end of the day, in the commission report, it didn't come out as a recommendation, despite our courthouse shootings and the pressure these days for multi-use courtrooms and multi-use facilities. We didn't really talk about maintaining core values, the whole public trust and confidence thing. It was never mentioned specifically, but if you read between the lines and a lot of the stuff that came out from the commission report there, you'll see a lot of that comes down to access and fairness and outreach and civics education and whatnot. We didn't talk about some of the other forms of public access, court documents, video connections, et cetera, remote hearings, those kinds of things. Accountability and transparency. Never did we talk about the dreaded performance management. Why? It depends on who's on the bus. On the bus were clerks and judges primarily, and they're very scared of those things. And naturally, as we went through our discussions, it kind of got hinted at, time standards, performance measures, et cetera, and as quickly as those words were uttered, they disappeared quietly into the ether. And that was okay. There were those of us in the room that said, oh my gosh, they said it for a moment, let's talk about it, please. But we didn't. We let them go and have their conversation in the directions that they felt they needed to on bigger issues. Because at the end of the day, these are merely issues and items that will help them achieve and get to and respond to those trends. So they didn't necessarily need to say that they needed to adopt performance measures or things like that, because those will support them getting to where they need to go. I didn't talk about business intelligence and big data and those kinds of other things that might come up if you all do it. We also didn't talk about personnel concerns. We've heard here in our keynote speaker this morning talking about the millennials. They're going to be the ones that say, hey, can I just come in at noon? And I'll work till 10, 11 o'clock at night. And I'll only come in for 8 days, and then I'll take a 4-day, weekend. That may be okay, and that may be a norm in 20 years. And when we talked about that and we did some of the generational discussion with the commission members, they weren't ready to get their arms around those issues. That was too concrete, perhaps, about what their workforce might be looking like in 20 years. But I would encourage you all, if you'll do this at your own local level, talk about those things. Talk about the retirements of your baby boomers, that transition and retention of your current staff, that knowledge transfer of all those people that are retiring, and what the professionalization of your court staff is going to look like. I made the comment of, are the millennials and the Generation Xers that are in your workforce in the court system, are they talking about retirement? Are the rest of us that might be a little bit older, do we care about how much is in our 401k and how its performance is doing? Yeah, and then we're worried that, in 10 years when those folks get to be our age and they realize that they've hopped around to 5 jobs and they never created a 401k that they put money in, they're going to start thinking a little bit differently perhaps, and they might want to stay with a government entity like the courts because of that job security and that ability to have, in some places, still a pension, if you even have one of those, but in the rest of the world, 401ks and retirement plans. So a lot of these things are going to have a great impact, I think, on what our courts are going to look like in 20 years, and it's worth talking about, whether it's with your judges, your commission members, clerks, et cetera. So lastly, what did we do? We obviously issued a quick press release. We sent it to all the key people. Electronically, we blanketed as many people as we can. We sent out the nice glossy blue-covered, pamphlets and stuff to about 500 people. Our key legislators, the chairs of our prosecutor's council, our public defender council, key people in the governor's offices, all our key judge councils, all those kinds of folks, our sheriff's association, our chiefs of police, our local Georgia Bureau of Investigation, all those head honchos, pardons and paroles, corrections, probation, legal services, all those people got a handful of hard copies, and then several electronic copies were pushed out there. That report's floating out there. I was in a meeting in Atlanta on Friday, sat next to an attorney that's working on a state e-filing committee, and he pulled out of his briefcase a copy of it. And he started quoting from it in our state conversation about e-filing, trying to say, hey, remember what the Next Generation Courts Commission talked about e-filing and e-access? We need to keep these principles in mind as we're developing a state policy. Our state judicial education body is already working on things. We have an audit going on by our Department of Audit that's talking about some of our judicial functions and some of the overlap. Apparently they got a copy of the report and they're saying, let's talk about some of these overlapping kind of things and what's going on with them. We didn't talk about unification, but they were talking about some of the other types of issues about standardization of forms and stuff and things like that where there might be some efficiencies. So sent it to all kinds of folks there. You can certainly look at the numbers. Went to lots of attorneys, clerks, and the executive branch primarily, and obviously we went to the key legislators as well at the House of Representatives and the Senate. So what did we end up doing? We created an internal action list that we gave to our committee members and to the commission members and asked them to take the report and go forth, share it, have local conversations at your local court or with your city council or your county council or whatever. Have those conversations about what the courts are going to look like and get on top of the issues. Start thinking about them. You don't need to make changes overnight, is sort of the message, but you need to be thinking about where things are going over the next 20 years. So we asked them to identify areas and agencies that might be key players and key stakeholders in moving forward on some of these recommendations. And we have an internal action list that will probably get the key members of the commission back together here in the next year, now that it's been out for about a year, and talk about, are things moving at all on any of these recommendations? And quietly, we know that some of them are. And like anything, it's evolving, and it'll go on the shelf and gather dust like other reports at some point. But it's the conversation that ultimately was important and I think was valuable. So certainly we would encourage you all, and here are both locations for the report with our state AOC and our state bar. We encourage you all to have this conversation at the local level, at your statewide level, or whoever is willing to be in the room with you. Get the right people on the bus, go through that future trend analysis. There's lots of resources out there. You don't have to make it up. Look at ours, look at some of the re-engineering that some of the other states have done. At the end of the day, have a productive, meaningful conversation about what the future looks like, and then be prepared to sit back and help make it a reality. So I'm here for questions if you all have any. I know it's the end of the day. It's rough, right? Question? You have a quick moment, yes.
How did you get the commission members to have a buy-in and put underrepresented their individual jurisdictional?
When the Chief Justice and the State Bar President send you a joint letter that they both sign saying, please, we'd like you to be involved in this, very few people say no. I mean, it's one of the nature where some positions of power have a great deal of influence, and that's one of them that if you're a member of the bar and the State Bar and your Chief Justice say, I want you to do something, that's a privilege. And the State Bar really helped us out by pairing us up with State Bar meetings so that it was convenient, and they created the commission and put it on their website and listed the members and stuff. So for those that are more politically savvy amongst the State Bar and stuff, it was meaningful for them to be part of this. Any other questions? All right, thank you all. Have fun.